Hello and welcome to today's webinar, the first in our series on digital transformation, episode 1, regulating AI, the European approach and the APAC perspective. Thank you all for joining. I'll start with a few joining instructions for those of you joining us from Hong Kong. We have applied for CPD point accreditation, and hopefully that will come through. But please bear in mind that you'll have to stay for the duration of the webinar in order to receive those. Please note we are recording this webinar. And with no further ado, then quick introductions to our panelists here today. My name is Mark Parsons. I'm a partner with the regulatory team here based in Hong Kong. We've got a great cross jurisdictional panel joining us from across the globe. Leo von Garlek, who's a partner with our IPMT team based in Hamburg, and Nicole Soren, who's a counsel with our litigation team in Munich, who will be speaking to us about the European approach to regulation. Andrew McGinty and Sherry Gong, who are partners based in Hong Kong and Beijing, respectively, who will speak about China's approach to regulation. I will briefly reappear and talk about Hong Kong, and we're joined by Mark Vincent in our Singapore office, who will speak about developments there, and Angel Zhang, who's a senior associate based in Sydney, who will talk about developments in Australia. And in terms of the approach to the webinar today, we thought it'd be interesting to speak first about the European approach, because it is just the most advanced approach that we see internationally, and then compare and contrast, go around the region here in APAC and talk about how regulators are taking very different approaches to developing the regulatory regimes there. So quite a packed agenda, a lot of jurisdictions to get through. Please feel free to use the Q&A function at the bottom of the screen to provide questions. We do hope to have some time at the end to respond to questions. If we don't get to you, though, rest assured we will. We'll endeavor to come back to you with responses to your questions. So with no further ado, then I'll hand over to Leo, who will kick us off with a discussion about really some fundamental questions about what we're trying to regulate here, what we mean by regulating AI, and then going into the European approach. Sorry, it looks like we're just waiting for our slides to get settled here.
Okay, Mark. Yeah, thank you so much. And I hope you can all hear me well. It's great to meet you. And while the slides are just coming on screen, let me tell you a little bit of what we're addressing today. So it's about regulations, different regulations of artificial intelligence. So the question is, why do we need regulation? What do we want to regulate? The first question there is, what is it that we want to regulate? So what is the AI system that needs to get a regulatory framework? Then the question is, what risks does it produce that deserve and require regulation? So we need to look at the specific type of risks. Then we need to look at the human side. Who are the persons, the contributors? What are the different players, the human players on the field that the legislator needs to look at in terms of risk mitigation and finding the right responsibility and attribute it and allocate it appropriately? And then, of course, with all the different jurisdictions, we need to look at geographies in order to get an understanding where is the relevant geographical space where something needs to be regulated. So it's the AI system, it is the risk, it is the human contributor, and it is the region that needs a little bit more attention in terms of what needs to be regulated. And if we start with the AI system, of course, one big question is, what is AI? And there are, of course, many, many different definitions around, and you have seen over the history of AI evolution that we came from a very logic-based approach and are now at a very machine learning, data extrapolation, probabilistic kind of state of art. And the question then is, how do we put this in legal terms, which is relevant, of course, because at some point we need to be in a position to say, yes, that is within the regulation or it's without. And there has been a wave of just attempts to get this into words, and that was 2019. 2019 is a very relevant year for AI regulation, in particular, as several international organizations like the UN, like the G20, tried to find a definition, but most of all the OECD, the Organization for Economic Development, looked into it and developed some principles for the trustworthy use and deployment of AI. And within these principles, there is a definition. And this definition is very useful in its own right, but it's also the basis for the definition that the European legislator has adopted. And there is now a tendency, we see this also in Canada, that legislators, it's at least a number of legislators, try to refer to it. And I also think that this makes really sense because it is a good definition. And let's have a look at what this definition says. So in the first line, no, if you go, thank you, at this slide, you see it means a machine-based system designed to operate with varying levels of autonomy. So machine-based probably means that it's not a biological system, but it is somehow something that works on the basis of semiconductors as we know it today, or some other form of artificial electronic just type of transmission mode as opposed to any biological means. But of course, at the end of the day, that will only be clarified once the court have a say on this, but it's probably excluding biological environments. And then it has varying levels of autonomy. This is very important because it means it's not a purely logic-based system. So there is not a full linearity in the sense of if something happens, then by certainty, something different comes out of this. If there is this predictability on the basis of a logical rule, it's probably not an artificial system. We need to have some degree of freedom, unknown outcome. This is the autonomy of the system that produces its outcome in a certain unpredictable way. And then we have that the system needs to exhibit adaptiveness, which is extremely important as well, because that means that the machine needs to be in a position to learn. So there is some self-learning mechanism, and that's by many kind of seen as the heart of what modern AI systems do, that they can self-improve over time on the basis typically of the data they infer. And then I think they infer by that mechanism certain conclusions from given data and produce output, as we have it here, predictions, content, and recommendation. So that's typically the result of the result of a human thought process as well, that it results into something that we say or that we do or that we decide. So it is very similar to what humans do in terms of its autonomous, yes, and its learning, but not biology-based, but machine-based. So with that, we kind of have an idea that this is a broad definition of AI, excluding probably pure logical systems. And then we go on the next slide, which tell us what are the risks that we want to regulate. And then it's, in a sense, very easy because it's all the risks that we have that are produced by human agents as well. If you look, for example, safety and reliability, of course, the physical integrity that nobody is harmed by a autonomously driving car. So physical integrity is certainly something that we want to protect and that this is a risk. Though system security, that no other valuables are harmed. For example, property in terms of just any property in terms of financial assets or real estate assets that may be affected by some machinery that is acting on its own devices. Very typical risks, both in the human world and in the artificial world. But then there's also intellectual property that may be just interfered with because we, for example, just exploit unduly the rights of any copyright holder or patent holder. And there may be the privacy that maybe needs to be protected because the system interferes with my privacy and with my personal life in a way that is seen as unduly intrusive. And we see this with then fairness, that there is also my right to be treated fairly and in an unbiased manner. Just as I expect that treatment from humans, I would expect to receive that treatment from a machine. So in a short word, it is all the risks that a human can be exposed due to human activity. Those are the risks that a human can be exposed through the agency of an AI system. So that's what we want to regulate. And if we then move to the next slide, we need to tie the AI system and the risks to those people we have that are somehow related to these AI systems. And that is necessary because at some point we want to decide whom are we going to hold responsible if something goes wrong? Whom do we hold accountable for applying all the duties, the obligations that we will see in the course of this presentation? And in a sense, we have a big divide between those who create the system, the providers, whom we have here on the very left. Those are the ones who are either creating, setting up an AI system and market it in their own name, or change it or adapt it in a very significant way so that it results to be a different system than it was before. And of course, that come in very different forms like foundation models, like application-specific models in any given area. So we have, as we just know from the different type of AI systems, we know that this is just a very broad array of different systems that can be developed or provided. Then we have, of course, the user that also may need to be regulated in a certain way, but we understand the user will need to be regulated in a different way than the provider. And then we have the people in between who facilitate one way or the other these services, for example, the importer or the distributor, just terms that are probably understandable by their very terminology. And with that, let's move on and look a little bit to geography as well on the next slide. You see where would the system need to show effect in order to fall under a regulation? So it's always the question is from the territorial scope, is there an application of any given regulation? And if we take the example of the EU AI Act, it has a very broad application, and that's nowadays the tendency with many regulations. It's, of course, any system that is produced or directly deployed in the territory. But more importantly, it is also applicable to any system, the output of which is used in the European Union, or where it has people affected by the system located in the European Union. So if the output is noticeable in the European Union, or the affected people are residing in the European Union, then the regulation is applicable, meaning that we have a very, very broad application of the regulation. And with that, I think we can move on and just see a little bit the landscape of different attempts to regulate this. And we will look in the course of this presentation deeper, of course, into the regulations in China and related regions. But then, of course, we have the regulations, the regulatory attempts in the US, where we have this executive order by President Biden, which takes a very specific approach in terms of very dedicated to specific sectors, to specific areas, so that we have an array of very different approaches depending on the sector in which a certain AI is used. So that is something like a sectorial approach, which differs markedly from what we have in the European Union. It differs markedly from what Canada tries to attempt with their draft AI and Data Act, which also attempts, like in the European Union, to have an all-inclusive regulation. Then we have again the UK, which is different again, is more sectorial, like in the US. And we will see how that just works out in China and some other regions. We see on the international level that there are many attempts. I said already 2019 was a relevant year where we had the OECD coming out with their principles, the G20 just utilized those principles by the OECD and made them their own, so that we have a significant alignment between these two international bodies spitting out principles. We have the UN, which has not yet developed a very deep understanding of how to deal with AI, unfortunately, I must say. And then we have the G7, and you may have seen this in the news, that there have been a number of documents coming out of the Hiroshima summit, where we have then produced a number of code of conducts, very specific, that may be just used as a standard in the absence of any more specific regulation. And with that, I think we can just now look a little bit closer into the AI Act. And before I hand over to my colleague Nicole, just very briefly, we have come to the end of the legislative road. The AI Act has now been approved by all relevant legislative bodies, and we will see it coming into effect later this year. The first obligations are deriving already towards the end of the year out of this act, and then we have a cascade of obligations that evolve over the next 3 years, depending on the area. But it starts already this year with those areas that are really forbidden for any AI use, as we will be seeing. And just a few, before we go into the details, a few general remarks. It is a horizontal approach, so it tries to cut across all industries. It tries to cut across all types of applications, and it really almost always looks at what is the specific risk that a specific application produces and then regulates it. With one marked exception, there is also a specific regulation on general purpose AI or foundational models that receive a just specific regulation in their own right. And then I think we also just need to understand it is at the end of the day, a security and safety just specific type of regulation that really wants to regulate the risks that we have seen before in terms of what harm can it does, and how do we make sure that at the outset those risks are mitigated and the obligations are applied so that whoever uses the system has a mitigated or reduced risk of any of those harms. And with that, I hand over to my colleague, Nicole.
Thank you, Leo. So on the next slide, we will see like the core of the regulation, the risk-based approach. And this is the pyramid that you can look at. We heard already from Leo that there are some of applications that are considered unacceptable and they are prohibited. These are, for example, cognitive behavioral manipulation, AI systems, or AI systems that are preparing or doing social scoring. So these are prohibited. They may not be used in the European Union at all. Then the next category are the high-risk systems. For them, a conformity assessment needs to be set up by the provider. And we will look at this in detail. And for the ones that are considered with limited risk, transparency requirements have been included, and the European legislator decided that for all other AI systems, there will not be any obligations, but a code of conduct will be set up that can be followed voluntarily. So this is like the construct that has been set up in the AI Act. And when we go on the next slide, please, we will see how the high-risk AI systems will be kind of categorized. As a definition, these high-risk systems are the ones whose development or malfunction could pose significant risk either to health or to safety or fundamental human rights of natural persons. So the idea is that either subsystems that are themselves products who have already been regulated by other European law, who will be integrated in such products, will fall under the high-risk categorization, or AI systems that themselves fall under specific areas. The so-called standalone high-risk AI systems will be categorized as high risk. And we outlined like the categories that have been included in the annexes of the AI Act at the time being. So on the left side, you see like examples for already regulated products like machines, medical devices, or toys. For motor vehicles, there's a little bit different story. They are excluded from the AI Act at the time being, but the specific regulations will be adapted so that they will kind of follow the structure included in the AI Act. And on the right side, you see like the standalone systems, and for them, it's more like the purpose-driven application. So any AI system that works with biometric systems, or it is in the area of critical infrastructure, if it's an HR tool or deals with employment, so it's more like a purpose-driven categorization, then it will fall under these kind of system. And there are also some exemptions, as you see on the lower bottom of the right side. If it's only a system that will support persons in their doings, then you can have a kind of an exclusion, and your system will not fall under the high-risk AI system categorization. So if you move to the next slide, please. Here we see like the personal scope when we have a high-risk AI system, in particular for providers. They are the kind of persons that will have the most obligations to take care of and to deal with. To start with, this is the AI literacy, something that has been included in the course of the proceedings in the AI Act. It means that the staff must be trained accordingly, that they must know what they are doing and how the AI system works. As I said, a conformity assessment procedure must be set up. and a conformity marking must be added to the product. A risk management assessment has to be implemented and monitored all the time. And also risk mitigation measures like trainings must be included and documented accordingly. And post-marketing monitoring systems also need to be implemented and checked. For limited risk AI systems, also the AI literacy has been now included as an obligation. And as outlined before, the transparency obligations, which means that persons need at least to be informed that they are interacting with an AI system, and that nature of deepfakes must disclosed, or if images have been changed or manipulated, so that people are at least aware that they are dealing with an AI system and not with a natural person. And on the next slide, we see what Leo already outlined, that in addition to this risk-based regulation, also some specific regulations have been implemented for general purpose AI models along the line of the procedure of the adoption of the AI Act. And these rules are kind of different to the ones I just described, since they are more like coming from another idea. So there also will have a technical documentation to be set up. So the idea is, if there is like a general purpose AI and a provider wants to use this for his AI system that he's setting up, that he needs to get the information from the one who has adopted this general purpose AI system. And also along the line of the procedure, we had additional rulings to be included for specific general purpose AI systems with systemic risks. These are ones that are deemed to have kind of similar effects like the high-risk AI systems on, for example, human safety or the human rights. So they needed an additional layer of regulation. And there are also some exception included. For example, if you have a free and open source model, then the regulations that I just outlined will not apply for your general purpose AI system. But if it's included or it falls under the definition of a general purpose AI system with a systemic risk, on the other hand, then no exception will apply. So there's kind of a different layer here that needs to be checked. So it's most important to see, if you have an AI system, in which category does my AI system fall, to really see which obligations and which regulations need to be applied to it. And we move on to the next slide. We want to look at the enforcement and penalty regulations that have been included in the AI Act. So there have been fines outlined that shall and will be adopted, and the member states will be responsible for that. So on the one hand, for the prohibited practices, if there's a non-compliance in this regard, the fines shall be up to 35 million or 7% of the total worldwide annual turnover, whichever is higher. So this is like the rule that has been included. And there's also an exception. So for startups, it will be the one who's lower. So the parameter that's lower of the both. For any other non-compliance with obligations that have been included in the AI Act, the fines shall be up to 50 million or 3% of the total worldwide annual turnover. And for example, not supplying correct or incomplete or misleading information, the fines are said to be up to 7.5 million or 1.5% of the total worldwide annual turnover. And what's important to notice here is that also the European Union itself will undergo these fines if one of their institutions will fail to apply regulations correctly. So this is a kind of a novum that not only the member states will have to enforce this, but also like the institutions themselves. And on the next slide, we see what Leo already outlined. So the idea of the application, we are waiting for the last formal steps, which are the approval of the council, and then the publication in the official journal. And then we have the entry into force 20 days after the publication. As Leo said, the application will start this year, at least for the prohibited systems, since the member states will have to take care that they are not used in the European Union market within 6 months after the start of the application. After 12 months, the regulations for general purpose AI will apply. After 24 months, the rules for the high-risk systems, purpose-driven ones, which are single system or standalone AI systems will apply. And after 36 months, the obligations for these high-risk AI systems that are already subject to other union harmonization legislation will need to be applied. And on a last slide, we want to give you kind of an outline on how to prepare and how to check if the AI Act is something that you need to take care of for your specific products or AI system, or if you're using an AI system. So in first step, we recommend to check if it's applicable, like to see through the regulation and what's in it. As I said, to see which categories your system falls under, or if you are included in the personal and territorial scope in this regard. Then to see and to check where to integrate the competencies and responsibilities in the governance system already implied in your company, to do a risk and gap analysis to see where some of the provisions are not taken care of at the time being, and to see for each system which specific obligations you would fall under, and then to implement this measure, like to set up the specific documentation procedures, to apply for conformity assessment procedures, and to make sure that anything is prepared and ready in one integrated system, so that you have it all in place and be assured and have all ready if anything comes up, so that you are set to take your AI system on the market, or to use it accordingly to the regulations. And with this, I will hand over to the colleagues from China.
Thank you, Nicole. So we are, given the timing, we are going to be doing a very rapid canter through AI in China and regulating AI in mainland China. This in itself is a vast topic, and we could happily talk for hours about it, but given we've only got a few minutes, we will have to go through this quite quickly. Now, this is the overview of what we'll be covering: what is regulated in mainland China, the governance approach, cases where AI enforcement related cases, and then the challenges for regulators and clients in mainland China. The first thing to notice about AI is that there is no definition of AI under PRC law. So there is a definite definition of generative AI technology, which is very, very generic, right? It refers to models and related technologies that have the ability to generate content, blah, 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 right? This is not particularly refined or sophisticated. And as we will see, there is a sense in China, I think, that a lot of this has been thrown together quite quickly, and that they are still continually refining the approach. And we'll see how that reflects in the legislation. Next slide, please. So here, I'm sure your eyes are all glazing over when you see this slide. There is a huge volume of legislation in China in this area. What I will do is Sherry will talk about the legislation plan and for the China model law and artificial intelligence in a couple of minutes. But I will focus on some of the key provisions in the AI space So just under AI, you can see their management of generative artificial intelligence services interim measures. And then you will see down below on algorithms, the algorithm recommendation for Internet Information Services administrative provisions. And then in the same section, deep synthesis in Internet-based information services administrative provisions. But as you can see, the approach in China is to throw a lot of legislation at it. And perhaps the underlying aim there is put out the legislation in a kind of lower level form, see how it performs, see what the issues are, see what comes out of it, and then wrap it all up in a big law that will actually cover everything. Next slide, please. So who, what, and why? Who is covered? Who's regulated in mainland China? Algorithmic recommendation service providers, generative AI service providers, and technology support providers. So for example, if you are doing deep synthesis and you are a technology support provider for a deep synthesis app, otherwise known as deep fakes, then you are within the scope of regulation. It's interesting to note how different it is from Hong Kong, where you don't tend to have a lot of statutory law or legislation. And it's also very, very distinct from the EU, where you have this breakdown into each of the different categories, right? So you've got your users, your importers, distributors, and so on and so forth, each with different obligations. The what, there is no, as we said, no single law in China on this. So it covers a slightly scattergun approach, generative AI technologies, algorithms, data. The why, well, it seems that there's a couple of factors at play here. First of all, China has had a raft of kind of deep fake type problems, but there's also, I think, an underlying theme here, which is also, there's also a political concern about how AI could have an impact. And we'll see that in the way in which China approaches the legislation. Next slide, please. So first of all, China has hard qualification requirements for algorithmic recommendation service providers, deep synthesis service providers, or providers of generative AI. And here is the magic words in China: public opinion attributes or social mobilization capabilities. If you have any of those, you need to complete a security assessment and an algorithmic record filing. I think it would be a brave lawyer who would go out and say that this AI function does not have public opinion attributes or social mobilization capabilities. They're also a question of what data can you train on, right? Because again, in China, there is a lot of sensitivity about certain types of data. There is a question about the reliability. So generative AI providers have to take measures to improve the reliability. And there is a requirement to mark deep synthesis service providers. So when the information has been generated based on deep synthesis, it has to be marked. And then you have certain user protections via platform and other agreements. Next slide, please. So this is a fairly busy slide. I'm not going to speak to all of this, but you will see that at the top of the pyramid, if you look on the left-hand side in the box there, the second box down, if the product, service, or application has public opinion attributes or social mobilization capabilities, you have to file the algorithm. If it causes any material change in public opinion attributes or social mobilization capabilities, then you are going to end up with a security assessment of the algorithm. You have obligations on app stores for deep synthesis apps. You also have ethical review. The ethical review goes quite wide. In fact, it goes down to the level of the enterprise. So if you are engaged in what are known as high-risk science and technology activities, which includes R&D of algorithms, applications, and systems with the magic words, then you need to carry out ethic review. Now, given the timing, I will skip over the other ones, but essentially, China reduces all of this to big principles. There's not a lot of detail in terms of what you actually have to do. So, for example, I'll give you just one example where algorithmic recommendation services must be provided in accordance with laws with respect for social morality, and ethics, business ethics, professional ethics, and in accordance with principles of impartiality, fairness, openness, and transparency, scientific principles, reasonableness, honesty, and good faith. Hard to get your hands around that when you're actually a business. Next slide, please. Now, here's some example cases. I'm not going to talk about all of those, but it is interesting that China recognized copyright in AI-generated images, which is different from the approaches that we've seen elsewhere in the world. Also, on the right-hand side, you will see this lots of face-swapping fraud cases, which have been a driver of legislation in China. Next slide, please. So what are the challenges for regulators? One, uncertainty around the scope and degree, right? Who is regulated? No single AI law, no risk-based level classification, and unclear as to where that AI law will come out on enforcement. Who even will be the regulatory authorities? Could be a whole alphabet soup of regulatory authorities. As you've seen from the legislation list, lots of different authorities involved. And ultimately, compliance costs, because if you are based in the EU and you have to comply with the EU laws, and you then have to put in place a completely different set of compliance rules for China, that is going to be an expensive exercise. Next slide, please. And with that, I will hand over to Sherry.
Thanks, Andrew. Talking about the legislative trends in mainland China, it's noted actually in early 2017, China government issued a new generation AI development plan, setting up several milestones. And in 2023, China government already announced that it has a plan to draft an AI law. So from some draft, particularly from the experts draft released in August 2023, and earlier this month, we have the China Model Law on AI version 2. They are actually prepared by experts. From those models, we understand that's likely the China AI Act may adopt a similar approach to EU AI Act by taking a unified approach to regulate all types of AI. Next slide, please. Let's take a look at highlights under the China Model Law on AI version 2. Interestingly, it proposed an approach similar to the regime regulating foreign investment. That is, it proposed a negative list. It said if the AI products or services fall under the negative list, a license or approval is required. But if it's not on the negative list, it only needs a record filing. So that's an aim to balance the need of regulations and the reducing the compliance burden. Also, the new version of the model law promotes development of open source AI and supports measures such as promoting construction of open source communities and clarifying rules for liability reduction in open source AI area. Also, like Andrew mentioned, AI can be copyright in China. So this draft sets up rules for intellectual property innovation, making special arrangements for using training data and personal data in R&D sector, and clarifying IP protection and the determination of infringements. So it's interesting to see whether the official draft will adopt these suggestions or not. Normally, the adoption of law in China will have 3 reviews by the People's Congress, and it may take months, 2 years. Next slide, please. We understand many multinational companies are looking at what's the environment for foreign investment in AI area in China. Generally speaking, multiple national companies provide AI service product to the public in China, not matter in offshore or onshore. It will be subject to the AI measures, including the requirement mentioned by Angel, like the security assessment and record filing. Also, as you may know, China also has strict content control on internet, may block offshore platforms and websites. So the majority of the open AI platforms are not accessible in China right now. And if you do AI service or product in China, you have to consider how to comply with personal information protection law, data security law, and cybersecurity law. They also may face the license requirement for value-added telecom services. So it's very challenges in foreign investors. However, we also noticed that China government recently have some major actions. For example, they open certain VAT services to foreign investment in certain free trade zone areas, Beijing, Shanghai, Shenzhen, and Hainan, and open certain ICP services to foreign investment. That means there's no shareholding ratio for foreign investors in this area if the company is registered in the special free trade zone, etc. Also, we noticed that the CAC issued the promotion regulation for cross-border data transfer. So narrow down the application of the CAC security assessment, and the majority of the companies can use the SECs and third-party certification. So it's largely reducing the compliance burden for entities to transfer data outside China. So we think those kind of actions are positive for foreign investors to consider develop AI services or products in China. However, at the same time, they need to consider the geography, uncertainty, export control in United States and China, etc. So a lot of factors contribute for this consideration. Due to the time interest, I will pause here and hand over to Mark.
Thank you, Sherry. So turning then to Hong Kong. Next slide, please. I'll try to be very brief so we managed to get everyone in. So the current status of AI regulation, there is no general AI law in Hong Kong. There are various bits and pieces of law and regulation that impact. The main piece is to look at the MA a number of years now ago in 2019 launched its high-level principles on artificial intelligence, followed a few years later by the Privacy Commissioner for Personal Data's guidance on ethical development and use of AI, and then which was in 2021, and then last year we had the Office of the Government Chief Information Officer publishing its ethical artificial intelligence framework, and I'll touch on each of these in a bit more detail. But the most recent news item is that the Intellectual Property Department has announced an initiative to review the copyright treatment of AI-generated content, promising a public consultation in the course of this year. So digging in a bit further to the MA's high-level principles on AI, in AI terms, this is a very old document. As I said, it came out in 2019. 5 years in AI time is an absolute lifetime. And reading it, you'll be struck that it really does appear to be very, very high level in the sense of essentially providing banks with a general direction to implement management structures to regulate AI, some reference to some basic AI principles such as explainability and auditability, and then linking back to the fact that the MA does have a fairly full book of technology risk management regulation, which touches on topics such as cybersecurity and general risk mitigation. I think this is probably due for a refresh, and as you see when we get into the further documents that have come out from the other authorities in Hong Kong, we're already seeing a more detailed approach in these other documents. So next slide, please. The Privacy Commissioner for Personal Data published an ethical principles document, which for those of you who have been reading ethical frameworks around the globe for handling AI, you'll see some principles, ethical principles, that are very familiar. These ethical guides often have different ways of categorizing the ethical requirements, but what you see here in this list, accountability, human oversight, transparency, and so forth, it's what you see in ethical frameworks more generally. And it does raise the question. So in Hong Kong, it really is the Privacy Commissioner from a data perspective who's taken the lead on a broader view of what AI should be and what it should do and not do. The regulatory remit, of course, is only in relation to personal data, and this raises a jurisdictional limitation really on what the Privacy Commissioner can say about AI, because as you dig into these principles, you'll see that yes, personal data issues are engaged across a wide range of these issues, but actually there are many AI applications that aren't really making much use of personal data at all, meaning that the regulatory remit isn't really as broad as the potential breadth of the guidance here. We are aware that the Privacy Commissioner is developing guidelines for the procurement of AI, which we expect to see later this year. And fairly recently, the Commissioner did run a compliance check on 28 local organizations making use of AI, which in terms of output seems to be more of a fact-finding exercise. There's no enforcement action that we're aware of taken as a consequence of that. And then finally, next slide, please. So the OGCIO, this is the most substantial document we've seen. And again, chronologically, it's the most recent document, the detailed ethical AI framework that the OGCIO has published has a slightly longer list of AI ethical principles you'll see there, and a much more detailed practitioner's approach to leveraging AI, which is really directed at AI developers, technology developers who are looking at how to develop algorithms, how to source training data, how to parameterize and fine tune, and so forth. So it's a very detailed, full AI lifecycle set of technical recommendations, which has no direct legal effect, but I think shows the direction that we're likely to see here in Hong Kong as other jurisdictions move forward to more prescriptive, more detailed regulation. And with that, I will hand over to Mark Vincent, who will talk to us about Singapore.
Thanks, Mark. So before delving into Singapore's AI regulatory framework, I'd like to cover Singapore's national AI strategy very briefly. Historically, Singapore has had to develop quickly out of necessity and attract inflow of foreign direct investments to advance the economy. At present, the key sectors driving Singapore's economy, all of which you realize are primed for AI transformation, include advanced manufacturing in the electronics, chemicals, biomedical sciences sectors, as well as financial and professional services. Against this backdrop, Singapore has always taken a sink or swim mentality and striving towards being ahead of the curve in exploring or implementing the latest technology with heavy investments in R&D. With AI, it is taking a consistent approach led by the government. In the latest budget announcement for 2024, the government rolled out a number of initiatives showing its strong support to enhance Singapore as a business and innovation hub in Southeast Asia. And you can see in the slides, the support ranges from funding of around 1 billion Singapore dollars over the next 5 years, earmarked to boost AI capabilities, grants, incentives, and programs for transformation of businesses and upskilling of the workforce, employment of AI professionals, and provision of scholarships to draw top AI talent to Singapore. In terms of sheer numbers, in the coming years, Singapore aims to triple its number of AI practitioners to 15,000 by training locals and hiring from overseas. Singapore is also working with top chip producers to procure and obtain access to chips for AI development, and collaborating with tech giants to set up AI centers of excellence here as part of its central push. Next slide. Now to jump into detail on Singapore's AI regulatory approach. Now, taking into account what I just explained in the slide before, we have to look at weighing Singapore's objectives in the AI space against the threats and challenges that AI implementation poses. Singapore has so far preferred implementation of non-binding guidelines, principles, and frameworks over binding legislation. At this nascent stage of AI development in Singapore, the intention behind this approach is to balance interests of facilitating innovation against safeguarding consumer interests, with the hope of serving as a global reference point for AI regulation. Now, whilst there is no overarching legal AI framework in the works as compared to the other jurisdictions that my colleagues have spoken about before, Singapore does have specific laws that targets part of the AI governance lifecycle from areas including data privacy, copyright, cybersecurity, anti-discrimination, and online safety. So it's not as if it's a completely unregulated area. Through this approach, the government is able to remain flexible and focused by implementing sector-specific guidelines, targeting AI adoption, and implementation in key sectors such as financial services, info communications, and the health sectors. We've provided some examples on the slide to show Singapore's push to guide AI ethical development and use. So in 2018, Singapore set up the Advisory Council on AI, which comprises of tech executives, senior state officials, and R&D specialists. The council is aimed at providing opinions on AI policy, engaging key stakeholders to position Singapore as a trusted AI ecosystem and hub. In 2020, the government rolled out the Model AI Governance Framework, an implementation and self-assessment guide. This collectively provides enterprises and businesses with a practical reference point in AI development. In 2022, in May, Singapore launched the world's first AI governance testing framework and toolkit named AI Verify. This helps companies to validate its performance of its AI systems against a set of internationally recognized principles. The next step on the agenda, the final bullet point of the slide, is the implementation of Model AI Governance Framework for generative AI. And this is in the works with hopefully more practical guidance to come. Now with that, I'll hand it over to Angel from Australia.
Thanks very much, Mark. I'll be going through the approach in Australia, and the short of it really is that there is no single approach and things are still up for discussion at the moment. So unlike in EU, Australia is yet to implement its own AI-specific law. Currently, aspects of AI are regulated through different pieces of legislation like other jurisdictions. So this includes the Privacy Act, online safety law, and sector-specific laws. So for example, therapeutic goods legislation regulates AI use in medical devices. There are also a number of voluntary standards in place, such as the AI ethics framework that companies turn to for best practice guidance. The Australian government has started to consider what form a regulation could look like, and ultimately it's a matter of trying to balance commercial innovation while ensuring that harms from AI are mitigated. Next slide, please. So in July last year, the Australian government released a discussion paper on the safe and responsible use of AI. It asked stakeholders to identify potential gaps in approaches to regulating AI in Australia and to consider what the preferred AI governance model would look like. The questions that were posed by the Australian government was, whether Australia should implement a regulatory regime similar to other jurisdictions such as the EU, or should we take a voluntary approach or some form of hybrid approach? There was also discussion on a potential ban on high-risk AI applications, such as facial recognition and social scoring. So high-risk AI application hasn't been defined, but it's generally considered to be applications that have high impacts that are systemic, irreversible, or perpetual. The paper also asked for industry input as to other forms of AI technology that may warrant a ban. Next slide, please. The government published an interim response to the consultation earlier this year. A few things arose from that. So the first is the general consensus from the industry was that voluntary guardrails are insufficient to regulate AI, particularly high-risk applications of AI. Secondly, there was particular concern directed at newer, powerful AI models that can generate content at a fast rate and be embedded in a variety of contexts. Thirdly, it's clear that the current regulatory framework doesn't adequately address AI risks, and some gaps are being addressed through reforms to privacy and online safety legislation. And there's currently a review of the Online Safety Act, which is Australia's national law on content safety on online platforms, as well as introducing new laws regarding disinformation and misinformation. And lastly, the government is now considering and consulting on whether mandatory guardrails for AI are appropriate, and if so, what mandatory safety guardrails are they, and what would the legislative vehicles look like? Next slide, please. So in the interim, the Australian government is developing a voluntary AI standard with risk-based guardrails for the industry, establishing an expert advisory body to support the development of options for further AI guardrails, and they're currently working with the industry to develop options for labeling and watermarking of AI-generated materials. Next slide, please. The challenge really for those operating in Australia and other jurisdictions is that, unfortunately, the regulatory landscape is unclear. It is a balancing act. So on one hand, the government doesn't want to stifle innovation and compromise Australia's ambition as a leading global tech innovator. And on the other hand, it is important to achieve a balance to protect Australians from potential harm of AI. There was also no mention of any plans of a dedicated regulator, which makes one wonder whose jurisdiction AI will fall under. For example, will it be a single regulator, or will they be regulated by a number of different regulators, such as, the privacy regulator or sector-specific regulators? There's concerns that this may lead to inconsistency between regulatory approaches across sectors. And even though the regulatory landscape is uncertain at the moment, the recommendation really is that companies should ensure that their internal processes and procedures are, allow for the safe, secure, and responsible AI development and deployment, but appreciate the practicality of that is quite difficult given the, uncertain regulatory landscape. And with that, I'll hand back to Mark Parsons to conclude.
Thank you very much, Angel. And I'm conscious we've come to the bottom of the hour. We have received some questions. We promise to do our best to come back to those who've posed questions, but unfortunately we've run out of time. Thank you all very much for joining, and thank you very much to our speakers. I will just finish with the next the concluding slide if we could. Apologies for jumping over, and please do feel free to, we've had a number of people pose questions. Please continue to feed those through. A very, very complex, fast moving area of regulation, and just from the discussion here, it's clear that as much as some jurisdictions have leapt ahead, there's many questions yet to be answered about the approach. At Hogan Lovells, we're taking a very active approach to engaging on AI issues. You see here on the left-hand side of this slide, our AI hub, which can be accessed through Engage Premium. And we do have a second installment of our digital transformation webinar series coming up, where we'll go in a slightly different direction, looking at AI liability. This first talk does a great job at setting the stage for regulatory approaches and directions taken by regulators, but it just opens up a whole series of questions around for users of AI, for providers of AI, developers of AI technology, the whole chain of the AI stack. How is liability going to be managed in this increasingly complex environment that we're headed into? So again, thank you very, very much to those who join, and to our speakers, and we look forward to engaging further with you on this very interesting area. Thank you very much.